Whatever actually real to it is hearing real hearing actually. So it is hearing of person, it is real. No, what is it? According to
Wait, please, Your Lordship. You have filed one criminal petition yesterday, my lord. Wait, that means this may come up on Friday, my lord. There's some urgency.
For what?
For motion.
What type of urgency?
This is passing of the order, my lord. 3 FIRs were filed, 2 has been returned in filing of FR, another on same set of incident allegations, another.
Friday, we are very busy. Can we take up on Monday?
Okay, my lord, this can be taken up on Monday. Most of this.
May I please, Your Lordship?
11.
For listing of criminal revision petition, Lordship. In this case, what happened in this case, Lordship? Originally, I was a complainant, Lordship. It's an anarch case, Lordship. Thereafter, Lordship, that accused was convicted, Lordship. Thereafter, appeal was preferred before the session judge, and then appeal was dismissed, Lordship. Thereafter, Lordship, they preferred this revision. I am the respondent in this case, Lordship. And the petitioner is, Lordship, this petitioner is, this respondent is more than 80 years old, Lordship. So can it be taken next week, any date, Lordship, for hearing?
Yes.
In fact, in this case, Lordship, this was listed in the part 2 list. So it may come next week, Lordship. Any date,
Yes,
Lordship?
yes.
Any date? Huh?
80 years.
12.
My lord, this is a criminal revision petition regarding maintenance, my lord. This may come up on Friday for admission because after motion, it was never listed.
Not
It
on
was the
Friday.
24,
We
my lord.
we have a lot many cases, and Friday we'll have to leave.
Then Monday, my lord.
Monday, Monday? Okay, on Monday.
May I please, Your Lordship? I beg to mention item number 18. I'm for the petitioner. In this case, TCR was called for, Lordship, but not received.
Okay.
18.
TCRS call for is not received. Issue reminder. List the matter. When do you want?
After 2 weeks,
2 weeks. After 2 weeks.
Lordship. Deeply blessed.
May please, the Lordship. Lordship, may I pray for listing of a bail application for motion tomorrow, my lord. We have filed it yesterday, my lord.
What kind of case?
My lord, this is a matter pertains to special act, my lord. Registered under POCSO Act, only section 12, my lord.
Motion for.
Yes, my lord, deeply okay.
May it please, Your Lordship. I beg to mention item number 8 of today's list, Lordship. It may be taken up at 2 p.m. Lordship.
At 2 p.m. Pari niki? Kiba ase niki? Hearing sharing?
Actually, the engaged cousin, Mr. Edas, is on the way to Gauhati and he will not be able to reach on time. So it may be taken up. Later half of.
If the hearing continues, it will continue. From first half, if the hearing continues, it will
Yes.
continue. After that, after end of that hearing, we'll take up that matter.
Obliged.
I cannot guarantee at 2 p.m., but we'll take up the
Obliged,
matter.
obliged, Lordship.
Because
Obliged.
if
In the second.
from first half, any hearing continues, then we'll take the first matter after that,
Obliged,
concluding that.
Obliged.
Item number 9.
8.
May I please, Your Lordship? Lordship, I beg to mention item number 29, my lord. CD is not available, my lord.
CDS call for is not received. Issue reminder, list the matter on. Are you on interim bail?
No.
When do you want?
Charge sheet subject discuss.
Oh, Sachet has been submitted.
Yes.
Okay. Item Dixon, item number 29, learned counsel, Mr.
Why, Ali?
Y. Ali is present for the petitioner. One petitioner.
Yes, my
Petitioner Rafiqul
Rafiqul.
Islam alias Rafiqul Islam. Learned additional PP, Mr. DP Goswami submitted that Sachet has been laid against the petitioner. Being
My case number 200/25, dated 14/8/25.
the petitioner is at liberty to approach the jurisdictional court stroke Elaka magistrate and apply for bail, which may be considered by the court in accordance with law.
Hi, Lord.
May I please? I pay for listing for tomorrow, my lord. There is a criminal petition which is disposed of on 29/4, my lord. But there is a correction in this order, my lord. So we filed the IA in yesterday, my lord. So kindly we listed on
Criminal petition.
criminal petition. NBW against the petitioner, against the accused, my lord.
On Monday.
Oh, my lord, he is
Tuesday.
apprehension of
Arrest.
arrest, my lord. His case is disposed of, my lord.
He was not appearing
No, my lord, there is some correction of this.
He was not appearing for how many days?
No, only 2
trial-
days, my lord.
The trial court, he was not appearing for only 2 dates.
2 days.
Okay, then tomorrow, yes.
Obliged.
May I please, your lordship? So, ladyship had allowed a criminal leave petition on April 27. It's an NIAC matter under section 419 of the VNSS. Ladyship, that connected appeal is now come on record. Ladyship, may please to keep it on Thursday, May 7.
Which are, which
It's criminal appeal 161 of 226. No, it's on come on record.
come on record?
Yes. Sure. Criminal CRLA 161 of 2026.
Oh, today?
No. It has come on record, but not listed today. Ladyship may put it on May 7, ladyship.
May 7th?
Yes, ladyship, because
For what?
we are being led by outstanding counsel. He will be physically present.
For what? Criminal appeal for what? Hearing?
It's an NIAC matter for hearing, ladyship.
Criminal revision petition for hearing?
Criminal appeal.
Criminal appeal
Yes, lordship.
for hearing?
For admission. The repetition has already been allowed. So the connected appeal now has
What type of
been
writ
registered.
petition?
The number of
Case, what type of writ petition?
leave petition was criminal leave petition 11 of 2026.
No, what kind of writ petition?
Leave petition.
So leave
Criminal
petition.
leave petition.
Oh,
Ladyship had allowed it under
yes.
419 of BNSS.
Okay, appeal against acquittal.
Ladyship, the leave
Here,
petition was.
not on, if it is for hearing, for admission, not on, when do you want tomorrow?
7, day after tomorrow, ladyship.
Right.
Because
Okay, on 7th.
obliged, ladyship.
No, 7 to Friday, no?
Thursday. 7th is Thursday, ladyship.
Admission or Thursday is a hearing date, no?
Right.
Admission to board submission দিব না একেটা
It
কোথায়
will be short. It's a short matter, ladyship. It won't take much of time.
leave was
Ladyship,
allowed. Leave was allowed.
Yes, leave was allowed on April 27 last
It's
week.
against acquittal only. If leave was allowed, it will be appeal against acquittal. So what is the urgency?
Ladyship, we are being led by the outstanding outstation counsel.
Okay,
So he'll be physically present. That's the only.
Okay, all right.
May 7, Lordship.
Yes.
Lordship, I beg to mention an IA criminal lordship. Any date next week, lordship. It's a 3 suspension of sentence application.
Your Lordship, I beg to mention a criminal petition for orders because the parties have settled the case for mediation. So we want to withdraw the case.
Civil or পাইম নাকি? পাইম নাকি? Civil or more?
Criminal petition, Your Lordship, it's a
Criminal petition.
criminal petition
For orders?
for orders.
When do you want?
Any date as per Your Lordship's convenience.
Detail.
13th. Much of it.
May I please your lordship? Yesterday, we have filed a criminal petition for setting aside the NBWA, which is listed on Monday. So I request before your lordship to list the matter on 7th May
Why?
for setting aside the NBWA.
7 May. 7 May is a hearing date. What is the urgency?
For setting aside.
How
the
many,
NBWA.
okay, I understand. How many dates you haven't appeared before the trial court?
This will be our first day.
Huh, sorry?
This will be our first day.
You haven't appeared before a trial court for the first date? Are you sure? If I find out then you haven't appeared for 8 dates, then I'll
I-
defer it for 3 months.
Earlier, before some other counsel were engaged.
No, not on 7th. বেলেগ এটা date দি দিয়ক। Thursday hearing day,
It will
no?
come up on 8th Friday.
No, 8. See, there is a problem. You come at the nick of time. If there is any urgency, you must come earlier, not at the nick of time.
It may be listed on 11th.
Yes, on 11th.
May it
Obliged.
please your lordship. Lordship, I beg to mention for listing on criminal petition. It was listed yesterday, but could not reach, my lord. May I
No,
put on 11?
why? Yesterday I have all the matters were
No,
over.
in port number 14.
What matter?
Matter, my lord, it is a Silmaris proceeding.
Hmm.
So, my lord, the matter is.
When do you want?
8 or 11th?
Dated 8 or 11th, dated 11th.
May please, your lordship. Item number 31, perhaps CD is not available, my lord. 31.
Is an interim.
CD has called for is not receive issue reminder, list the matter on all of lamba date deliver by interim order.
29th.
Interim order shall remain in force till then.
And another prayer for listing of criminal appeal in for admission, criminal revision petition for admission in any date in next week.
Next report.
All right.
Your Lordship. Your Lordship, I beg to mention a criminal revision petition for listing, Your Lordship. It's regarding maintenance, Your Lordship. The wife has been remarried.
Regarding maintenance, there is a video. Now, early.
May I please, Lordship, I beg to mention for a bail application, listing for a bail application for tomorrow.
Tomorrow is Wednesday. Motion,
Yes,
which sections?
69 BNSS.
69 BNS. BA.
Yes,
How many days is behind bars?
Lordship, I'm not aware about this.
Okay. As it is, we'll call for the CD.
Lordship, I beg to mention an unlisted IA in a criminal appeal, Lordship, regarding correction of a typographical error in the order.
When?
Today, Lordship.
Typographical error?
Yes, Lordship. Yesterday's matter. Lordship.
Yesterday's order.
Yes, Lordship.
Typographical error.
Lordship.
Yesterday there was a typographical error.
Yes, Lordship. In the order, Lordship. Case number was mistakenly, wrongly mentioned, Lordship.
What case number was wrongly mentioned?
Yes, Lordship.
Huh?
We mentioned
Di-
wrongly.
okay. Just tomorrow.
Lordship, there is an urgency, Lordship, because
Today,
he
you
was-
want it today?
Yes, Lordship.
Okay.
May I please, I beg to mention for listing one IA criminal, my lord. It was filed on 6/4, my lord. April,
IA
IA, my lord. In connected criminal appeal
for bail.
for bail.
What offense? What kind of offense?
Lordship, POSCO is there.
POSCO. When do you want?
On Monday, Friday.
Next week?
Friday, man.
No, not Friday. Next week, if next week any date.
Monday, man.
Monday by any.
Most
Okay,
of it.
on Monday.
Please, Your Lordship, regarding item number 18 in court number 24, my lord,
Hmm.
say that honorable court is not, justice is not sitting,
Wait,
so
just have a notice with me. What to do about it? Let me see. Code number 24.
24, my lord. So, my lord, it may be taken up tomorrow, my lord. Anyway, CD has not come, so only reminder will have to be issued. But
Okay.
if it is left out, my lord, it may not get listed in this week.
Code number 24 mo ki koibo parisna. I'll just check the notice. I haven't gone through the notice. It is for that all concerned today is this one. The single bench of will not hold court and the matters. All the matters are deferred. You'll have to mention before the registry.
No, there is a note in the later part of the notice that if there is
Later
any
part,
urgency.
okay, I haven't seen.
But if there is
I read only the first line. Therefore, and will be notified later on for listing of urgent matters pertaining to said bench, except the matters tied up before the single bench of his lordship. No, except the matters tied
Not
up.
tied up matter.
Okay.
Tomorrow, my lord.
It is not tied up.
Not tied up, my lord.
Okay, tomorrow.
Tomorrow. I'm deep local. Item 18.
May I please,
Econ court.
may I please, your lordship? Similar prayer, my lord. Item number 3 in court number 24, your lordship. It's in the motion column.
When
Maybe
do you want?
tomorrow, my lord. There is some urgency, my lord.
Don't bring it to my court.
Tomorrow,
Okay.
my lord.
Lordship,
Alia.
I beg to mention item number 3,
Mention memo de bolivia.
please sit down. 8 of April.
8th of April, item number 3.
Item number 3.
Your name?
Sayandale.
Learned Counsel Ms. So, on behalf of Learned Counsel Mr. Triple S Roman
Yes, sir.
has paid for adjournment, list the matter on 18th.
8 of April, Friday. 8 of May.
No,
May,
not
May.
it, not
On-
it, not it. Not it, some other day,
11. Okay.
11th.
May it please, Lordship. Lordship, item number 21. May I kindly adjourn and with a issuance of reminder, the CD, it was fixed for CD, but its CD is not available, Lordship.
CDS call for is not received, issue reminder, list the matter on
29.
20.
Lordship, 12 May, only 3 days only can gone, Lordship. Only 3 dates.
150 days in custody, so 30 days remaining, 28 or 29.
No, so for CD, I'm not asking for charge sheet. No? This is for charge sheet. This is not CD.
29.
It's too long, Lordship.
No.
I'll be short date make I'll be given, Lordship.
No point.
Obliged.
May it please the Lordship, I beg to mention the criminal petition for hearing, Lordship, 14/5 may possible, Lordship,
Fine, hearing 14/5.
or 28/5.
28/5 now, 14/5 hearing, fine. Hearing day. Okay.
14/5.
May I please?
Obliged.
Criminal petition for motion, Lordship, tomorrow. Urgency, Lordship.
What kind of petition?
Lordship.
What kind of petition?
Petition, Lordship, what happened? I filed an application under Section 12 of the DV Act seeking maintenance for my husband, who is a police official. Twice my interim prayer was rejected by the learned trial court. Then this honorable court directed the husband to continue to pay the maintenance. And accordingly, accumulated maintenance stood at 2,28,000. Accordingly, learned trial court issued distress warrant. And that order was sent by the session, before the session judge, Lordship. And session judge, without hearing me, stayed the distress warrant. There is a direction from this honorable court to continue the maintenance, Lordship.
Tomorrow.
Lordship, because the in session court, the case is posted on 7th, Lordship, day after tomorrow. Much appreciated.
May I please, Your Lordship, I would like to mention for an adjournment of item number 4 of the daily list. 4,
Learned Counsel, Miss
Chayanika Burman,
C. Bormon, on behalf of Learned Counsel, Mr.
P.D. Bhuya,
Learned Senior Advocate, Mr. P.D. Bhuya has paid for adjournment. List the matter on when?
after 2 weeks.
After 2 weeks.
May it please your lordship, one criminal petition need to be listed, maybe after 1 week.
Deduct data.
Obliged.
Lordship, I beg to mention item number 20.
Mm.
We have some difficulty today. Can it be listed next week? Lordship?
Learned Counsel, Mr. A. Mr. has paid for, have you taken consent?
Bail
Oh, bail application, okay. 20, no? Or 21?
20 or
21? 20. Has paid for adjournment. List the matter on. Do you have the CD or?
Scan copy of
Can
Okay.
received.
List the matter. When do you want?
Anytime next week, Your Lordship.
Data video.
Lordship, I also beg to mention an AB for listing, Your Lordship,
Mm.
if possible tomorrow or day after tomorrow. As per your convenience. Lord.
Which, what is the section?
Section is Lordship under mischief to animals and cattle act, Lordship.
AB.
Yes, Your Lordship. We are apprehending arrested Lordship for some emergencies.
7th.
Obliged, your lordship.
May it please your lordship, I beg for listing on criminal petition lordship. Next week, any date lordship.
Data video.
Next week, any date. 15.
I beg to mention item number 28. Up to date case diary was called for, but that has not been received. So
From Satya, किती लगेंगे? 23rd. April ना May है?
May.
20 May.
I send you.
No, CD not.
Up to date case diary as called for is not received. Issue reminder to positively forward the case diary without fail on
May.
data deduction.
21st May.
21st May.
Obliged.
May it please your lordship. Matter may withdraw lordship. Petitioner does not want to press the matter anymore lordship. Same matter, it has come on daily list lordship, item number 14. It is listed 2 times.
Cannot be dismissed on withdrawal. We'll have to pass orders on merits. This is not petition, this is criminal revision petition. 447.
No lordship, transfer.
Oh, transfer application.
Transfer
Okay.
petition,
Transfer
lordship.
application, okay.
Yes.
Okay.
In daily list also same matter has come, item number 14 lordship. Same
Same matter in daily.
Same
list.
matter,
Okay.
lordship. Wrongly listed.
Learned counsel Ms. J. Ghosh
J.
is
Ghosh.
present for the petitioner. Principal Judge Family Court. Can I dismiss it? I don't think so. Family courts matter. You'll have
Matter
to,
has been compromised, Lordship.
you'll have to place this matter before a special
Special-
division bench. Registry to list this matter before a special division bench.
Similar, same, similar.
It's from family court, no?
Yes, Lordship.
You'll have to.
Criminal petition, Lordship, 42 item.
Learned counsel Ms. J. Ghosh is present for the petitioners who have filed this application under section 528 of the BNSS 2023, challenging the impugned DB case number 2 of 2024 under section 12 of the Protection of Women from Domestic Violence Act 2005. Full stop. The petitioner, the learned counsel for the petitioner submitted that the petitioner is not willing to proceed with this matter. Okay. Learned additional PP, Mr. DP Ghosh is present for the respondent number 1. This petition is hereby dismissed on withdrawal.
Obliged, Lordship. Wait, please, your Lordship. Lordship, as per client instruction, matter may be withdrawn, Lordship.
Withdrawal. Bail application.
Lordship,
Learned counsel Miss
as per bill,
S. Parveen
on
Yes.
behalf of A.S.A. Hamid.
is present on behalf of learned counsel
A.S.A. Hamid,
H. A. Ahmed.
Lordship.
Mr. H. A. Ahmed and has submitted that as per client's with instruction, withdrawal may be allowed. Learned additional PP, Mr. D.P. Goswami is present. Petition is dismissed from withdrawal.
Wait, please, also, as per client's instruction, the regular bail application may be withdrawn, Your Lordship. And for the anticipatory bail, Lordship may allow a liberty to file a fresh petition.
Okay. BA to लिखा 40 to 44 BA. Learned counsel Miss
A.N. Hussain.
A.
N. Hussain.
A.N. Hussain has prayed for withdrawal of this application as per instruction of the client. Learned additional PP, Mr. D.P. Goswami is present. Petition is hereby dismissed on withdrawal. याद एक लिखा learned counsel Miss A. Hussain ना A.N. Hussain is present for the petitioner and has submitted that as per client that the client has that instructions were received from the client for withdrawal of this application. Learned additional PP, Mr. D.P. Goswami is present. Petition is dismissed on withdrawal with a liberty to file a fresh petition.
Obliged, Lordship.
May I please?
Yes,
Lord?
please.
In this case, my lord, one motor vehicular accidental, my lord, the death case, my lord. Kindly have a look at page 10, my lord, at first, my lord, page 10.
Yes. Page 10, no?
Page 10, my lord. There's a case has been registered under section, my lord, 279 and 304A, my lord. And my lord, immediately after the, my lord, accident, my lord, the FIR has been lost, my lord. And thereafter, my lord, the matter has been amicably, my lord, settled in between the, my lord, parents of the deceased, my lord, deceased son, my lord, with that of the, my lord, accused person, my lord. But my lord, as the my lord already case has been registered, my lord, that's why police has declined to my lord accept their my lord compromise, joint compromise, my lord, and subsequently, my lord, the case has been charge sheeted, my lord, and still now, my lord, the petitioner, the accused person, and the parents of the deceased person, my lord, they have amicably settled, my lord, and there is understanding, my lord, and they have, my lord, jointly filed this petition, my lord, jointly filed, my lord, to quash the, my lord, FIR as well as the, my lord, proceedings in, my lord,
You have
PRC
any
case.
authority?
My lord,
3048, you have any authority?
my lord,
What
kindly
are
have a
proceedings?
look at page 14, my lord, page 14, my lord, page 14 onwards.
No, any authority, any judgment?
Oh, my lord, my lord, I have so many, my lord, from this honorable High Court as well as the accused. Eh, There's a Supreme Court as well as in our High Court. There are so many judgments, my lord. Because I have only few judgments I have placed before your lordships. And all the cases, my lord, pertaining to section, my lord, 279 and 304A, my lord.
Which, you show just one, any one.
My lord,
You show just one, any one case will work
my lord.
from this High Court, any one case.
That is, my lord, this case is, my lord, a criminal petition number 992 of 992 of 2023, my lord.
Then I'm sending back this.
Yes, my lord.
Everyone radio file. Yes. Your relevant part?
Relevant part is, my lord. That is, my lord, para 10, my lord. Para 10 of
Please read para 10.
para 10 of page 4, my lord. Page
Please read.
4 of.
Yes, please read. Please read.
The similarly in Parbat Bhai Ahir and others versus State of Gujarat reported in 2017-9 SCC 641, the Honorable Supreme Court has observed as under the broad principles which emerge from the precedents on the subject may be summarized in the following propositions, my lord. Preserves the inherent powers of the High Court to prevent an abuse of the process of any court or to secure the ends of justice, my lord. The provision does not confer new powers, it only recognizes and preserves powers which inhere in the High Court. The invocation of the jurisdiction of the High Court to quash a first information report or a criminal proceeding on the ground that a settlement has been arrived at between the offender and the victim is not the same as the invocation of jurisdiction for the purpose of compounding an offense. While compounding an offense, the power of the court is governed by the provisions of section 320 of the Code of Criminal Procedure 1973. The power to quash under section 482 is attracted even if the offense is non-compoundable, my lord. In forming an opinion whether a criminal proceeding or complaint should be quashed in exercise of its jurisdiction under section 482, the High Court must evaluate whether the ends of justice would justify the exercise of the inherent power. Next, my lord, while the inherent power of the High Court has a wide ambit and pursuit, it has to be exercised to secure the ends of justice, my lord. This very principle, my lord, to secure the ends of justice and to prevent an abuse of the process of any court. My lord, my case is, my lord, similar situated, my lord, covered the principle, there's these two principles, my lord. As because, my lord, the.
Okay, all right. Please read the affidavit. Please read the affidavit.
My lord, affidavit, my lord. At first, my lord, in page 15, my lord, relevant portion, my lord. In page 15, that affidavit is shown by the, my lord, mother of the deceased, and my lord, another, my lord, affidavit that is at page 18, that is shown by the father of the deceased person, my lord. At first, my lord, I would like to come at page 15, my lord. Page 15, the page 15, my lord, that is para 3, my lord. Para 3 is a relevant portion, my lord, that I do state that after the said accident, I along with my husband have settled the matter amicably with the accused petitioner number 1, Syed Ali, as he has also sustained grievous injuries on his person, and we have compromised the matter in presence of the elderly persons of the locality and submitted the same before the investigating officer in charge Manipur PS, whereby we have resolved to withdraw the case, and since then we have no any objection and allegation against the accused petitioner number 1, Syed Ali. And still now, I am not willing to proceed the case against the accused petitioner number 1. I do say that in spite of the fact that we have compromised the matter amicably, said case has been charge sheeted against the aforesaid accused petition number 1, and same is pending before the learned CGM Bongaigaon. That I do say that as I have already settled the dispute with accused, and I am not interested at all to proceed the aforesaid case against the aforesaid accused person.
Okay,
and
it's
hence,
okay. Have you annexed the copy of the charge sheet,
uh,
the list of witnesses?
I have not annexed, my lord.
Then have you given any affidavit that they are the parents of the accused or parents of the victim
This is evident.
in the petition?
Yes, sir.
Which paragraph?
Affidavit, my lord, at page 15, my lord, that my husband, namely Noor Islam, has lost an FIR on 13/11/2020 before the officer in charge Manipur PS against the
No, this
writer
is
of
the
the
copy, certified copy.
certified copy of my.
You mentioned in the petition?
In the affidavit of the petition.
Yes,
They have jointly filed that.
jointly filed, my lord.
And affidavit is jointly.
No, not that type of affidavit.
Well,
You see, this case is compromised. They are
Yes.
not the informant. So in the petition, have you mentioned that they are the parents of the victim who have settled the dispute?
Statement doesn't give it. Petitioner.
Have you
petition-
mentioned? in the
yes, my
petition?
lord, yes. Petition.
Which paragraph of the petition?
My lord, para 5, Roman 2, my lord.
Golden again. Guitar with golden.
Page 5, my
Oh,
lord, page 5,
Page 5, Roman.
page
2.
5.
Dictation to deem problem.
Para 5,
Mm.
page 5, clause 2, my lord.
Yes, please read.
For that, at the initial stage of investigation of the case, the informant petitioner number 2 and petitioner number 3 and accused petitioner number 1 have amicably settled the matter between them, and HS, the investigating officer, ought not to have proceeded the case and ought not to have submitted the charge sheet, as all the concerned parties have settled the matter amicably in presence of elderly persons of the locality, and as such, other paragraphs also, my lord, there are some statements, my lord.
Okay, petitioner number 3.
Petition number 1 is the my lord, accused, my lord, and petition number 2 is the my lord.
Father?
Number
And
2 is the
petition-
father, mother, my lord, mother.
Okay.
Mother of the deceased, my lord, and petition number 3 is the father of the deceased, my lord.
And where their names have been, okay, but they just mentioned. Have you mentioned that you have filed a affidavit relating to this file in this petition? File affidavit
Before the my lord,
about these two affidavits, page 15 and 17. Have you mentioned the petition about these two affidavits?
yes, my lord, yes.
Which paragraph?
That is my lord, para. That is para, my lord, paragraph, my lord, 3, page 3. Page 3, para 3, my lord.
Page 3, paragraph 3.
Para 3, my lord. Very much specifically, my lord, stated, my lord.
Annexes, annexure 2 and 3.
My lord.
Okay, we can
My lord.
dispose it off at the. This Said Ali is the accused.
279.
Said Ali is the accused.
My lord, my lord.
Third learned counsel, Mr. S. Ahmed, for the petitioners. Said Ali, Aisha Khatun, and Nur Islam, who have jointly filed an application under section 528 of the BNSS 2023 for quashing the impugned FIR in connection with Manipur PS case number 466 of 2023 under section so and so, and the entire proceeding of PRC case number 38 of 2023. Heard Mr. D.P. Goswami, learned additional PP for the state of Assam. Full stop. The petitioner number 1 has been accused in connection with PRC number 38 stroke 2023 arising out of Manipur PS case number 466 of 2020. Full stop. The accused number or the petitioner number 1 is alleged to have been involved in an accident which resulted in the death of Anes Ali, son of petitioner number 2 and 3. Charge has been laid against the petitioner number 1, despite the fact that both the parties, i.e., the parents of the deceased as well as the accused, have amicably settled their dispute. Full stop. In para 3 of the petition, it is clearly mentioned that the matter has been amicably settled between the parties in presence of elderly persons of the locality. Full stop. Compromise deed was submitted before the IO, whereby it was resolved to withdraw the case, and since then, the petitioner number 2 and 3 are not willing to proceed, prosecute the petitioner number 1. Full stop. Annexure number 2 and 3 are the affidavits submitted by petitioner number 2 and petitioner number 3, stating that Nur Islam had lodged an FIR on 13/11/2020 before the OC Manipur PS against the rider of motorcycle number AS 26A2195, namely Said Ali, who was involved in an accident resulting in the death of their son, Anis Ali. The motorcycle was registered as 2195. What was it? Now, both the informant, the mother of the victim and the accused have jointly filed this application to quash the proceedings. Full stop. The petitioner has relied on a decision of this court in connection with Nur Nasib Ahmed versus the state of Assam in another, in connection with criminal petition number 992 of 2023, wherein, by order dated 9/1/2024, it was held that it was observed that paragraph number 2 absurd paragraph number 10 I have considered the submissions at the bar with circumspection, reverting back to this case. No, I have considered the submissions at the category. Reverting back to this case, it is held that as the informant himself is not willing to proceed with the case, and as the aggrieved, and as the other aggrieved person, i.e. the mother of the deceased, is also not willing to proceed with the case, further proceeding will indeed be an abuse of the process of the court. Plausibility of conviction appears to be remote and bleak. Full stop. The invocation of the jurisdiction. It therefore appears that the inherent jurisdiction may to quash the entire proceeding may be invoked. In view of the following discussions and after considering the submissions at the bar, the proceedings of PRC case number so and so arising out of the FIR, i.e. Manipur PS case number so and so against the petitioner registered under section so and so, and the charge sheet submitted under section so and so is hereby set aside and quashed.
Obligement. Much obliged.
May I please, your lordship? My lord, in this revision, my lord, important question of law is involved, my lord. My lord, your lordship, my lord, I am challenging the order, my lord, page 42, my lord. Page 41, your lordship will first come, my lord. Page 41, order dated 17/12, my lord. Before coming to impugn. My lord, on 17/12/25, my lord, it was fixed for copy and offense explanation, my lord. So copy was not given to me. It was only fixed, my lord. So next that your impugn order, page 42, lord.
Okay.
Page 42, annexure F, my lord. Well, here, my lord, what happened on that day, my lord, the complainant was absent, my lord. And my lord, the accused, my lord, the petitioner is present, my lord. And copy was furnished to him on the said day. But on the same day, my lord, the learned magistrate, my lord, jumped to the stage of cross-examination, my lord. He has, my lord, taken all two, 3 stages of the case clubbed together on the very same day, my lord. Within few minutes, copy was furnished, my lord, in absence of the complainant, and the magistrate, my lord, taken the, my lord, the my lord, denial of the defense. Although, my lord, defense plea was not recorded, my lord. Your lordship will see, my lord, he has written, my lord, 3rd paragraph, admission in bold letter, admission denial under section 330 of BNS and defense plea recorded in light of the direction of the Honorable Supreme Court in so and so. So my submission, my lord, on the same said date, only copy was furnished to me, and the next date, as per the provision, my lord, has to be given after 30 days or within 30 days for offense explanation. But the learned magistrate, my lord, stated that admission, denial under and defense plea recorded. My submission and defense plea will come after offense explanation, and no defense plea was been recorded, my lord. Now, second thing, my lord, the law, my lord, which the learned magistrate referred, my lord, Supreme Court 2010 5 SCC, my lord. That also I have taken a print out, my lord. I have gone through, my lord. That is a wrong proposition of law. It is not that citation is also wrong, my lord. And thereby he came to a, my lord, illogical conclusion, my lord. My lord, your lordship will find, my lord, on question of law, even he's relying on that judgment 2010.
You see, I don't know about BNSS, but I know once the offense is explained,
Yes.
it is not like framing of charge.
It is not prevailing.
The hearing is not required.
Offense explanation has not been taken care, my lord. Only copy your lordship will see. May I read
On
it?
the date of
Same day.
submitted, yes, when the day copy is given, then he can explain.
He can explain.
Yes.
If the provided, my lord, the case is taken up as a summary procedure. But the learned magistrate, next page, your lordship, page 42.
You are giving the judgment cited by the.
Yes.
This
Cited
will
by
not
the
help
learned
you.
magistrate.
No, see, this will not help you. Once you see hearing on offense explanation is not required. BNSS, I don't know.
No,
Let's see.
my submission is
Let's
not-
see the BNSS.
Your lordship, I am going by the impugn order, my lord. He has referred to section 330 of BNS.
That's what I'm going to check.
Lordship will see.
BNSS.
Yes, my lord. 330, your lordship will see. 30 days time is the mandatory required to fix a date. On which date he has to take a decision, my lord. I have brought BNS, my lord, 330, my lord. For formal proof of documents. I'll read, my lord.
Yes, please.
No formal proof of certain documents. When any document is filed before any court by the prosecution or the accused, the particulars of every such document shall be included in a list, and the prosecution or the accused or the advocate for the prosecution or the accused, if any, shall be called upon to admit or deny. I was called upon on the same day. The genuineness of each such document. Soon, my lord, what is, my lord, soon, after supply of such document, and in no case later than 30 days after the supply. Same day, my lord, not a single day was given.
It is what he has done. Before 30 days, he will have to explain.
No, my contention, my lord, he has served a copy, my lord. Copy is furnished, it is. Today is the date for copy, my lord. I appeared. The learned magistrate has served a copy upon me. But after few minutes, on the same day, my lord, I was asked to admit the documents. That is the thing, my lord. 330 says, my lord, soon or after, within a
But
limit
he has
of.
denied, no? He has not admitted.
My lord?
He has denied, no?
He has denied, my lord, because.
Then he has not admitted.
No, denied that. That's why, my lord, entire
No,
offense explanation is
See,
given.
you do not have a case here.
No, my lord, may I?
No, you do not have a case here.
My lord, may I read the whole order, my lord? Because your lordship will see the concluding remark, my lord, your lordship is very, very, my lord, beyond the law, my lord, page 43, my lord.
See, it has to be within 30 days, not after 30 days. What I gather from 330.
Yes, my lord, but I am not.
But you have convinced me it is after 30 days, so I have gone through the.
No, my lord, what I am
section.
saying, my lord, I may be wrong, my lord. No, in no case later than 30 days. I am saying, my lord, not
It
a
has to be
single.
within 30 days, no?
Not a single day was given, my lord. Now your lordship, one more thing, my lord.
So, but he has denied it, no? And you say this is an interlocutory order explanation.
No, my lord, I have also, my lord, submission on that. That is an intermediate, my lord. My humble submission, my lord.
You have any judgment?
I have
This is an
judgment,
interlocutory.
my lord, my lord.
Intermediate
Yes,
order.
yes, I have thoroughly prepared, my lord. But only thing, your lordship, may I read?
You have the judgment today?
Yes, I have it.
Okay, give it to me, let's see.
My lord, may I complete the order, my lord? Because he has stated, my
You
lord,
have denied, no? You have denied.
no, my lord, what
I
happened?
can allow you, see, I cannot set aside this order, but if he has cross-examined, then I can give you an opportunity to
My lord, he has applied.
cross-examine.
May I submit, my
If he
lord?
has been cross-examined, if he didn't get time, then I will give you an opportunity to be cross-examined.
No,
There's no point going here and there.
my lord, one thing, your lordship will appear, page 43, my lord.
Huh?
Page 43, my lord. Because this last portion is very, my lord, disheartening, my lord. Page 43, my lord. Lordship will kindly read it, my lord.
Yes.
After considering the amount in question and the fact that there is a possibility of imposing a sentence in excess of 1 year in the event of conviction of the accused, my lord, I am not inclined to try the case in a summary manner. So he was converting it itself to a summon procedure, and section 143 NIX says it has to be done after passing a reason order and after hearing the complainant. My submission, Lordship, complainant
That's
was
concern.
143, my lord. That's why I'm, my lord, referring to only question of law, my lord. Section 143, my lord. Proviso, my lord. I will read it, my lord. Okay.
143.
My lord. Of the amended provision 2003. my lord.
Yes.
I will read it, my lord.
Yes.
Power of court to try cases summarily. Notwithstanding anything contained in the Code of Criminal Procedure, all offences under this chapter shall be tried by judicial magistrate of first class or so and so, and the provision of section 260 to 65 of the said code shall, as far as may be applied to such trial, provided that in the case of any conviction in a summary trial under this section, it shall be lawful for the magistrate to pass a sentence of imprisonment for a term not exceeding 1 year and an amount of fine exceeding 5,000. Next is important. Provided further that when at the commencement of or in the course of a summary trial under this section, it appears to the magistrate that nature of the case is such that a sentence of imprisonment for a term exceeding 1 year may have to be passed, or that it is for any other reason undesirable to try the case summarily. This is important, my lord. The magistrate shall, after hearing the parties, he was afraid, my lord, complaint, record an order to that effect, and thereafter recall. My submission, my lord, no order was passed on the same day, my lord. He have to hear the complainant and me, my lord, before proceeding, converting into a summon procedure. And I'm supporting, my lord, it should be expeditiously disposed of. But he, my lord, learned magistrate has taken in the case as a summon procedure, my lord. Summon procedure, my lord, then 143 is violated.
What is hearing?
My lord?
What is hearing?
Hearing, my lord.
Offense under section 138 NI Act is explained to the accused to which he has pleaded not guilty. This is hearing. What kind of hearing you want now?
My lord, there is two part, my lord. Magistrate converted the case to a from summary procedure.
No, there is no two part.
Without hearing, my lord, the complainant.
There is no two part. Hearing is hearing.
No,
He
no.
was offense before
complainant was
explaining
absent.
the offense. He was heard,
Not heard,
and
my
he
lord.
has pleaded not guilty.
Your lordship will see section 143, hearing the complainant and the accused, my lord.
Why don't we dispose it of finally?
Your lordship may
Will
kindly.
stay order? Will issue notice?
No, my submission, your lordship may set aside this order. I am going to contest, my lord, from the offense explanation. Because the
No,
entire amount.
can it be set aside?
My lord, my lord.
Today?
Your lordship, because I am, next date is on 18th of May. It will proceed from the offense explanation. I am contesting, my lord, because the complainant amount is given by third party in cash.
You will have to convince me that this is an order to be set aside.
Yes,
This
my
is
lord.
not an interlocutory order.
Interlocutor, I
You
have
should
just.
not conclusively decide the rights of the parties. You will have to convince me.
Lordship, I have one judgment, my lord, Omit Kapoor. Just now I got it, my lord. Paragraph. When it causes miscarriage of justice, my lord, or there are jurisdictional error, my lord, then your lordship may interfere on that point.
You show me the jurisdictional error in this case, Omit Kapoor's case.
Para
Only
8
the error you must show.
Para
Of the
8,
conclusion.
my lord. Your lordship will find, my lord.
Yeah, finally.
No, I leave it to your lordship, my lord. Only thing, my lord, since date is fixed on 18.
Date, huh?
Next date is fixed in 18/5 of cross-examination, and even I have not got the offense explanation, and even the, my lord, procedure has been turned into a summon procedure. Now,
What
how
is the allegation against you?
allegation, my lord, 20 lakhs amount, check was issued and it was dishonored. And I am saying that I have no legally enforceable debt because check was issued to some other person. Page 20, lordship will see, the main person who gave the money, he is not a complainant, my lord.
And then he does not want to pay the debt to this person also, to the other person also.
No, I am not saying that, my lord. whoever is legally liable for enforcement
Yeah,
debt,
we
I
are
have to
talking
pay.
justice, that is why I'm asking.
Page 22, your lordship will see. It will clear, my lord.
Page,
22, my lord, check amount.
no, I do not want that. It's okay.
Complainant is my lord Gautam Das, and the
It's
check
okay,
was issued.
he is not bound by any legally enforceable debt. And he is not required to pay back the money he has
Yes,
borrowed.
yes, Lord.
But you show me the
My lord.
legal point in this Amit Kapoor's case.
Omid Kapoor, my lord. There, the Honorable Supreme Court has said, my lord, when there is some jurisdictional error.
No, you show me the jurisdictional error.
Page
I do
paragraph,
not want to find the conclusion of the Supreme Court.
my lord.
Because I cannot find any jurisdictional error.
There is a differences has been given by the my lord Supreme Court on exercise of 397.
No.
Power
Show me the jurisdictional error.
jurisdictional error in
NI case.
in the NI case.
Yes. This is an NI case.
This is not NI case.
No, it will not work. I will not read this and that case.
There are other judgment
In
also.
some
My,
case relevant to this case. Exactly. Jurisdictional error.
exactly, my lord. That I have to take out, my lord, some
That's why I'm asking. If you want to convince me, because I'm not convinced at all.
regarding the order, my lord.
Exactly. Because you see, we'll need, earlier we used to read commentaries.
My.
Now we do not read commentaries because judgments are available through AI. So you give me a judgment, otherwise it will be very difficult. I won't do the research work. This is
No,
your case.
Now, my submission, my lord, is that, my lord, on question of law is that 330 of BNSS provided within a period of 30 days.
But you told me earlier after a period of 38
No,
days.
my lord, I read it, my lord.
I'm really not convinced. Stay, I will not grant. I'm really not convinced. In fact, I do not know finally whether you'll find any judgment. I have doubts.
My lord,
But if you can find, then
your lordship will fix it.
well and good. No?
Fix it on next week, my lord.
Meanwhile, we'll issue notice and call for a trial court records. You can take back your judgments
Well, only thing is that my apprehension, my 18.5 is for cross examination.
before 18.5. See, you are giving the scope of cross examination also.
My lord, only thing is when the magistrate converted it.
All right, it's okay.
Someone-
You bring any judgment.
Someone
Right,
consider-
okay, but here you could not convince me. I'm really sorry. Our learned counsel, Mr. B. Borwa,
My lord.
for the petitioner who has filed this application under section
430.
new sections, no?
Yes, 430, revisional power.
438, read with section 442 of the BNWS 2023, challenging the impugned order dated 21/1/2026, passed by the learned Additional Chief Judicial Magistrate Dibrugarh in NI case number 20 of 2025. Issue notice to the respondent returnable to the data deduction returnable 18th or agot deduct. It won't come back, but even then I'm trying to okay 15 out of episode 9 নাই বন্ধ আছে 18 দিব লাগিব ডাইৰেক্ট ন
Well, also
ঠিক
you can
আছে
fix on 18.
15 I can fix on 18
Not, I'm sorry, 18 I will not be there. 15.
okay 15 over 15
Yes.
meanwhile call for the scanned copies of the trial court record of NI case number 20 of 2025.
Well, also will observe, my lord, prayer for. My lord, that prayer may be considered on next date, my lord.
No, without the judgment, I won't observe. You bring the judgment, then
My
I
lord.
will observe.
On interrogatory order, my lord.
Yes, exactly like this.
Like that.
The case has to be like this
My
because
lord.
you are we are dealing with some merits of the
Merits
or
of-
jurisdictional error. We are
Yes.
dealing with jurisdictional error. We'll need, because this is new, absolutely new.
Absolutely
Everything
new.
is new. So
Otherwise, 397.
without judgment, it will be very difficult.
My lord, I will bring them.
And by the way, whatever you have submitted, I did not find any flaw in the order. That is the problem.
My,
So I'm asking for a judgment to accommodate you.
my. Oblige.
May I please, your lordship? My lord, washing for my lord FIR, my lord, because my lord,
On the same subject matter, my lord, two FIR were registered, my lord, and I have come for quashing the subsequent FIR, my lord. So at this stage, notice may issue, my lord, and case diary may be called for, my lord.
Learned counsel, Mr.
S.A. Sikdar, my lord.
S.A. Sikdar is present for the petitioner. Issue notice to petitioner,
Respondent number 2.
only cheating cases, no family matter.
No, my lord. Only sitting.
Petitioner Amsuman Pujari, who has filed this application. Who has filed this application under section 528 of the BNWS 2023 with prayer for quashing the criminal proceeding based on FIR number, based on the FIR registered as Golaghat PS case number 171 of 2025 under Scientific Substance. Learned additional PP Mr. D.P. Goswami is present for the state of Assam and has accepted notice on behalf of the respondent number 1. Full stop. Issue notice to the respondent of number 2, returnable within 4 weeks. Call for the scanned copies of the trial court.
No. Case diary. Case diary. Investigation stage.
Yeah.
Yes, my lord. Case diary of, my lord, 2, cross cases also there, my lord.
Call for the case diary.
My lord, of my lord, 2 cases, my lord. Our affair, my lord, Golaghat PS case number 50/26, my lord.
Wait.
My lord, because we filed earlier, my lord. Our affair also is, my lord.
Why 2 cases? Other cases not considered, no, while dealing with, you want 2 case diaries, you want 2 case diaries.
Only one, this case is essential, other case.
We'll call them, Call for the case diary of which case?
My lord,
So
Golaghat.
your case will suffer.
My lord.
You're calling your case also, no?
Yes, my lord.
Then the investigation will be stalled. Your case will
My
suffer.
lord.
Do you want your case to suffer?
Scan copies, if possible.
Call for the case diary of
Golaghat PS case number 50/26.
Golaghat PS case number
171.
171 of 2025. This is
Yes.
case against you.
Yes, my lord.
And the scan copies of the Golaghat PS case number
50/26.
and scan copies of the case diary of the Golaghat PS case number 50 of 2026.
26.
This was
Because-
filed
Because
earlier.
earlier, it was filed earlier, my lord, but it was not registered, well, subsequently registered.
List accordingly, 4 weeks, no?
My lord.
List accordingly, 4 weeks, we pass नहीं होगा.
6 is in.
Oh, see. I take 5 minutes break.
Actually, I'm praying for an adjournment, madam, of item number 34 of court number 24, my lord. So matter may be listened, my lord, any day, my lord, next week. Actually, it was a criminal appeal, my lord, and matter is pending since 2022. I was supposed to be disposed of, my lord.
Matter tied up. Is this matter tied up?
No, the deferred, my lord, all matters deferred, my lord.
Pending is.
Next week or any date, DDR.
It was fixed today.
My lord?
It was fixed today.
Yes, my lord, it was fixed today.
Item 6.
May please your lordship. My lord, item 6 also, my lord, notice may go, my lord, and PCR may be called for, my lord.
CD.
Sarcited matter.
Huh?
Sarcited matter, my lord,
Sarcited
PCR, my
matter,
lord.
okay.
Scan copy of PCR.
Learned counsel Mr. S.A. Sikdar,
My lord.
who is present for the petitioner. Issue notice to the learned additional PP. Mr. D.P. Goswami is present for the respondent number 1 and has accepted notice on behalf of respondent number 1. Issue notice to the respondent number 2, returnable within 4 weeks.
My-
Call for the 4 weeks, no?
My-
Call for the scan copies of the trial court records, list accordingly.
Hello.
Along with scan copies of CD.
Lordship.
May it please your lordship.
Yes.
My lord, the instant petition, my lord, for under section 528, my lord,
Hmm.
for quashing of the proceeding of DV case, my lord, in the pending before the judicial may say first class null body, my lord. Lordship, before taking to this case, my lord, I entered with the marriage with the respondent number 1 on 15/12/2024, my lord. By suppressing the mental health condition of the respondent number 1, my lord, she entered into my marriage, my lord. After, my lord, 3 months of my marriage, my lord, suddenly she left during the Ramzan period, she left my home, my lord. Then we have tried to contact, she blocked my phone contact, my lord. Suddenly, my lord, in the meantime, in the petitioner, after 10 years of this 10 months, then I suddenly received a notice from this DV notice, my lord. And then, my lord, I came to know her intention, my lord. Then, my lord, I immediately filed one restoration of conjugal right. During that period, my lord, in her room, my lord, I found certain documents, medical documents, my lord, wherein this, since before my marriage, 2021 to, my lord, even before my marriage date, my lord, she was suffering some mental serious condition, my lord. The medicine she used to take is schizophrenia, my lord. Schizophrenia medicine, my lord. Whereas Honorable Apex Court, my lord, it is held that schizophrenia, if suppressing this disease, if someone entered into the marriage, this is a null and void, this is a marriage, my lord. So, my lord, after 10 months, my lord, suddenly I lost Nisit, and moreover, my lord, she lost the DV case against me. My 89 years father, respondent number 2, petition number 2, he is suffering from throat cancer. My 2 elder sister, one is married and one is unmarried. My elder sister, one sister residing with me, my lord. This is the case after 10 months of her. My lord, kindly have a look. The notice, Annexure 2, page 29. Page 29, my lord. This is a notice issued to me and all my other, my father, my sisters also received, my lord. We have been asked to appear on this concern that occasion, my lord. And all the notices I have enclosed here. Then lordship will find the petition, Annexure 3, page 32, DV case, my lord. DV case 45 of 2000/25, my lord. Lordship will find very first page, my lord, at page 32. Tohidur Rahman, the present petitioner. Petitioner number 2, my father, Khurshid Ali, aged 89 years old. I have enclosed the document that he is suffering from throat cancer, my lord. Then 3 and 4, 48, 49, they are my elder sisters, my lord. And 4 is the married. She resides some other place, my lord. And I am the only son who has to look after the father, my lord. Then page 33, my lord. After 10 months, my lord, this is a story she has narrated in the facts, and especially paragraph 3, my lord. That after 2 months of the marriage, that means marriage took place on, my lord, 15/12/2024. After 2 months of the marriage, the opposite party number 1, along with opposite party number 2, that is my father, 89 years old father, cancer patient, my lord. 3 and 4 started abusing the victim, but physically male. These are the common ground, my lord. It is most intelligently drafted this petition. Accordingly, this DV case, she has filed, notice issued to us. Now, lordship, Annexure 1, page 19, kindly have a look. Yes, once page 19, my lord. This is my father's. He is admittedly he is suffering from throat cancer. That is diagnosis, my lord. Page 19. Page 19, my lord. This is hypopharynx. That is throat cancer, my lord. My father, respondent number 2, petition number 2. Then, lordship, the interesting part I'd like to going to take your lordship. Page 44, Annexure 4 series. The medical, she was under medication before my marriage, my lord. All the medical testimonials, I have collected. Page 44. Lordship will find very first page, my lord. That is date, my lord, 8/1/2022. That is before my marriage, my lord. That is respondent number 2. This is Najia Ahmed, my lord. Kindly note it, my lord. Now, my lord, important page 46 and page 55. Page 46, my lord. Page 46, lordship will find date 2/11/2023. Now, the first medicine, my lord, RX, Tab Quantum, 100 mg. That is Tab Quantum. This is the patient, the doctor prescribed this medicine who is suffering from schizophrenia, my lord. That tablet Quantum. Then same medicine, 2020 onwards, continued to, my lord.
But this is not a divorce case.
My lord?
This is not a divorce case.
No, my lord. She suppressed this mental schizophrenia. She was suffering from schizophrenia. Then that's why this, my lord, knowingly she entered to the marriage.
It is not her fault.
My lord?
Unfortunately, this is not her fault. That she is
My lord.
suffering from schizophrenia.
My lord, It is, I'm not shameful. By suppressing this fact and her family, herself, she and the wife, had it been knowledge.
She is not aware of anything
Well,
because
she's
she's
the entire,
suffering.
of course, my lord. This is a medication she's
She's
taking. This
suffering, maybe her family. is
suffering, my
aware.
lord. Of course, she's visiting the doctor, my lord. This is a prescribed medicine, my lord. Page 55.
So these are grounds for divorce.
Absolutely.
Schizophrenia is
Yes,
ground for
lordship, absolutely true. This is a ground for divorce, my lord. Then, my lord, knowingly, my lord, despite this mental disease she was suffering, my lord, why she has entered to marriage to me, my lord? If and my lord,
she is suffering from mentally disease.
then why her parents and his
Maybe her
my
parents
lord,
are-
by suppressing this fact, my lord, and when this fact came to know, my lord, then she, after 10 months, my lord, she left
Ma'am,
after
and
3
this
months
case
of
is
marriage.
pending at which stage?
My lord, and judicial measure first class Nalbari.
At
My
which stage?
next date on tomorrow, my lord. For written statement, my lord. And my father notices asked to appearance for my father. He's admittedly suffering the cancer. My two elder sister, one is married, my lord. So, my lord, my humble submission led and moreover, my lord. Thereafter, I made an RT application, my lord. What page 60, my lord. Two annexure I like to draw your lordship kind attention, my lord. Annexure 5, page 60. When these medical documents I received, then I immediately made this RT application. This regarding those the treatment undergoing on. Ultimately, reply given to me, my lord, page 61. Why I have made the respondent number 2 here? This is the only reason, my lord. It is written to me by the secretary SPO, very bottom line, my lord. However, treatment documents can be provided to you if the honorable court instructed special.
In a divorce case.
Well,
Schizophrenia is a ground for divorce, but you are asking for restitution.